Looks like people are ready. Are you Mr. Mitvalsky? How'd I do on the name?
Well, Your Honor, thank you.
Say it right. Okay, not bad. All right. Thank you.
Good afternoon, Your Honors, and thank you for granting further review. My name is Rich Mitvalsky, and I represent the applicant, Susan Hutchinson, in this case. May it please the Court. The focus of our application for further review is the issue of reasonable diligence within the framework of the equitable exception to the one-year time limitation for actions to set aside, vacate, modify final judgments. And for a full understanding of the factual background of this case, I would kindly refer this court to the findings and the ruling of the district court, because in its decision, the district court really laid out what exactly happened in this case. And in our view, respectfully, what the Iowa Court of Appeals gave insufficient weight to. We requested further review because the evidence in this case does not support overturning the logic and the reasoning of the district court on the issue of reasonable diligence. In particular, the Court of Appeals decision that Susan Hutchinson could have discovered Greg Hutchinson's fraud in this action, his complete concealment of a second retirement account in which he participated.
Right there. The GE consent form, which I think is a big part of what we're talking about. In the district court, they talk about one box being checked, and when I look at the actual document, I see one box being checked, and yet the Court of Appeals talks about two boxes being checked. That makes a difference in my mind. Can you help clarify which one's correct?
Your Honor, and I want to treat this very respectfully, because when I reviewed the statement of facts in the applications for further review before this court and the resistance, I think it could be clearer than the way it was briefed here in our documents before this court. It was correctly done, and the facts are correct in the brief that we filed before the Court of Appeals at page 22 of that brief, and in the district court's ruling at appendix page 244 and 245. Your observation is spot on. There's a factual misunderstanding here.
Court of Appeals.
The district court is correct. And Mr.
Thank you. One more step further. Okay, let's assume that, and I'll let the other side tell me otherwise, but assuming the district court was right and only one box was checked, and I'm looking at that document, and if that's true, even if your client had received it back, which there's a big argument that she never got it back, the whole reason the lawyer never checked either box was that lawyer was unclear which plan was involved. But even if they had gotten it back with only one box checked, that's what everyone expected to be, just one box, correct?
Honor. And what happened here, where there were two forms, not one, the GE consent form that Mr. Hutchinson provided to Susan Hutchinson and her attorney at the same time that he signed a document swearing under oath that he had produced and disclosed all of his retirement assets, was a consent form. And that was the GE consent form that Susan signed, did not check a box, returned to Greg Hutchinson. But what Mr. Hutchinson did was he took that GE consent form and took it together with a separate consent form that appears in the appendix at page 117 and 118. That's called a GE beneficiary designation form, separate form. That is the form in which Mr. Hutchinson checked two boxes denoting his participation.
Correct.
Right on the document at page 118.
Then how come when you look back at that original GE consent form, and you're right, that other form, it makes it clear, but the GE consent form says when your client signed it, I understand that it is my responsibility to carefully review the beneficiary confirmation. Help me with that.
In the moment that that form came through, and I think it's important to go back to the situational context when that form is presented. This is a 20-year marriage. And over the 20 years of that marriage, Susan Hutchinson knows her husband participates in one retirement plan. She also knows when that form is presented to her attorney that Mr. Hutchinson was under a mandatory disclosure order requiring him specifically to produce all information relating to retirement assets, pension assets. What Mr. Hutchinson does is he produces or he discloses the existence of one retirement account with $126,000 of value, which matches exactly the full extent of Susan Hutchinson's knowledge over 20 years of marriage. And so it is in this situation, it's in this circumstance, at the same moment that he swears that he's produced all of his retirement assets to her, that this form comes in.
Some wily people going through divorce. There's a lot of trust that's out the window when people get divorced. Your client had a lawyer. Can you help me get beyond that aspect when we're looking at whether or not?
And the way I would do it is this. I would say this. In the moment that that form comes in, the question presented is which one of these accounts correctly reflects the $126,000 account. And when we look at that form by its express terms, it does not say that the user of this form participates in both of the plans identified. Additionally, the two retirement plans that are identified. One is called a GE savings plan and the other one is called the GE pension. But this court knows from its decisions, past decisions, in re Marriage of Benson, which is really a landmark family law case from this court, and reiterated in the Sullins case, that pensions include defined contribution plans. The language from those rulings is that in Iowa, there are two main types of pensions, defined benefit and defined contribution plans. And so what is in the mind of, because of the conditions that Mr. Hutchinson shaped himself, is that we're looking at a form and just trying to identify, she and her attorney were trying to identify just which one correctly identifies the name of the plan that has been disclosed.
And that she knew about, according to testimony. And am I correct that the record's pretty clear that he acknowledges he did not reveal the pension?
You are correct about that, Your Honor. And in addition, his testimony at pages 300, 301, 314, 338, and 339 make it undisputed that that second form didn't go anywhere other than from Greg Hutchinson to GE. Never provided.
Shift gears to another issue, which is the question of, what does the rule provide? The rule says, Rule 1102 says, on timely petition, and then Rule 1103 says that that's within 1 year, you can vacate a judgment for irregularity or fraud practiced in obtaining it. And that's what you're claiming. There was irregularity or fraud practiced in obtaining the divorce decree. So how do we get beyond the 1 year limit that's in the plain language of the rule?
There's an equitable exception that Iowa case law establishes, and it is if the fraud that was practiced in obtaining this judgment was extrinsic fraud, not intrinsic fraud, but extrinsic fraud, then that is an exception to the 1 year time limitation.
Extrinsic fraud is like fraud in the factum. That's like these extreme cases where somehow there wasn't a fair court proceeding, not clients lying or misrepresenting their assets or filing false documents. I mean, if we grant relief here, don't we open up all kinds of judgments to being unwound years after the fact? What's unique about this case?
Unique about this case, and it really gets to the heart of the difference between intrinsic and extrinsic fraud, and it's this. Your Honor, it's one thing to conceal information, facts, and evidence about a subject matter that is known to the parties, known to the court. It is an entirely different thing. That's intrinsic fraud. It is a different thing to conceal the subject matter itself. And I'll explain, because the latter is extrinsic fraud. When a party conceals information, facts, and evidence on a disclosed subject matter, take the pension, it's fraud, but it's intrinsic fraud. It doesn't warrant vacating a judgment, and the reason is, and the case law speaks to this type of language, the subject matter to which the fraud is directed is known to everybody, and that affords the opponent party the opportunity to marshal evidence to meet that fraud. Now, there might be an adjudication on that subject matter that is erroneous or incorrect if the opponent party didn't go get her own evidence to meet the fraud. But there is an adjudication because the subject matter is known to the court, known to the parties.
Okay, let's take a personal injury case, all right? Somebody files a personal injury suit. They say, I'm badly injured. They present their case. They get a substantial verdict. And then later on, it turns out they had a pre-existing medical condition that was never disclosed and was lied about. The defendant can come in and take away that personal injury verdict years after the fact?
I think it's hard to imagine that happening for a variety of reasons that are a little bit.
In our court system all the time. I mean, not by defendants and plaintiffs, and I mean, people don't tell the truth all the time. It's an unfortunate reality.
I agree, Your Honor, and I should say it clearly. It's hard to draw a parallel from that to this type of an example. What I want to
say that the fraud is intrinsic when it occurs during the course of trial, because the obligation is on the other side to expose the perjury or falsehood during the course of cross-examination and discovery. Here, it's outside trial. You're relying on the rule and the voluntary disclosures for reaching a settlement, the whole purpose of which is to avoid the trial, right? I mean, that's what makes it extrinsic. And our case law is that it happens pre-trial under an obligation by law to disclose the fact, which was not disclosed. Is that fair?
act of concealment that kept the subject matter of the pension extrinsic to the proceeding. There could never have been an adjudication on the merits.
My personal injury example, same thing. They don't disclose it in their disclosures. They don't disclose it in discovery. It's not found out until after trial.
Well prepared to deal with your example in personal injury setting.
I mean, there has to be some limiting principle to this equitable exception to the literal language of the rule that you're talking about, and that's what troubles me.
The equitable exception, the limiting principle is this, and this can be a rule announced in this case, is that if you yourself are responsible for the concealment of the facts and circumstances, that you are blaming the other side for failing to discover, not simply because in your example, the defendant didn't know about it, didn't discover it. It depends on what the discovery was in your example, Your Honor. But in this situation, if you had a defendant who affirmatively concealed something in a way that the subject matter itself could not have been known, then that's a limiting principle, but it might darn well justify vacating the judgment. And here, just to kind of return to the point, when you do conceal the subject matter, the lack of knowledge of the existence of the subject matter itself means you don't know that there's a case or a claim or a defense to assert because you don't know that there's a subject matter to assert it against.
Subject matter, is it what retirement assets does he have? And in this case, he had two, or is it the pension is a different subject matter?
To be a different subject matter. This pension ended up being a defined benefit pension that would have needed to be divided using a particular procedure known as a qualified domestic relations order. And I think there's some merit to that because it's also true that by reason of the concealment, that entire process couldn't take place. And I think that, and I'm talking about kind of a post-decree process, and I think that that's important to remember because in a footnote in the Court of Appeals, the majority says something like this. If Greg Hutchinson wouldn't have complied with Susan trying to obtain a copy of that GE consent form, which we now have established didn't contain the two checkboxes, that she would have had some sort of recourse to the court. She wouldn't have. There's no contempt action to bring at that point in time. And the only post-divorce process that would have been available to deal with something like this would have been the post-divorce process by which a qualified domestic relations order is entered, the very process that was foreclosed by the concealment of the asset itself.
Reminds me, she filed an affidavit of financial status. He never did. Is that correct? And often in divorces, if there is one filed, the other one may not file because they're content with whatever's been filed. Did the mom, the wife, ever list two, or did she only list the one in her affidavit?
One, and I see my time is about to expire. May I have just a moment to finish the thought?
And I might have a question too.
I was only going to say this. He did not sign an affidavit of financial status, but the stipulation of settlement contains an Exhibit A that contains a property disclosure, and he essentially signed the equivalent of that of an affidavit of financial status, Your Honor.
Counsel, I was just going to ask, what's the limiting principle here? The problem with this is every time after a trial, after a settlement, another party finds out that in discovery, a different party lied or concealed something, they're going to be coming to this court asking to reopen it. How do we put some limiter on this? I mean, when is the end, even if, yes, there was a lie?
No question that the principle of finality is an enormously important principle in everything that we do. But I would say this, in order to prove fraud, you also have to prove materiality. And there's a limiting principle there. That tells us that there are certain things that are not going to be material to the overall outcome. We're not talking about reopening cases because trivialities. But what we are talking about is this, a rule that says if you engage in fraudulent asset concealment in Iowa divorce courts, violating mandatory disclosure orders on things that were specifically enumerated, you should not be able to expect to shift the fault for not being able to discover that asset to the other party, the asset you concealed. You can't whipsaw people that way. And my time is well expired, unless there was another question.
I think we're okay there.
May it please the court, counsel. I want to start with the intrinsic versus extrinsic fraud issue. I think this court's decision in Maurer versus Rhodes from 1977 sets forth a pretty good definition of what those two concepts are. And intrinsic fraud is defined as occurring within the framework of the actual conduct of the trial and pertains to and affects the determination of the issues presented. And examples given are perjury, use of false or forged documents, concealment or misrepresentation of evidence. Extrinsic fraud is basically fraud that keeps a litigant from presenting his case. And the examples there given are a bribed judge, a dishonest attorney, or false promise of compromise. I think another way of looking at it is intrinsic fraud generally deals with the merits of the dispute, particularly the evidence that's presented or not presented. Where extrinsic fraud relates to collateral issues, such as having a fair tribunal to decide the case. One of the questions that Justice McDonald asked here, I think kind of is important here. Here, the alleged fraud relates to concealment of an asset, which is conceptually not all that different from false testimony or evidence. The actual fraud alleged here is the stipulation and the decree incorporating the stipulation. The stipulation and decree, which are signed by the parties, represent that all assets have been disclosed. And of course, the pension plan is not included in that. And the way that stipulation was created was Susan's attorney proposed it. It went back and forth a few times between Susan's attorney and Greg. They made various changes, and then ultimately everyone signed it and it was presented to the court. I think it's important to keep in mind what a stipulation is. A stipulation in part is an agreed upon statement of the facts submitted to the court in lieu of testimony and exhibits. Basically, it is the trial. It's the evidence that is presented to the court for the trial in a stipulation.
That your guy had been honest, correct?
There is. And it's certainly the stipulation, when you sign the stipulation, when he signed it, he's representing, I have disclosed all assets. That's a representation. And that's what the alleged fraudulent conduct is here, is not...
Ask you the same question I asked him, because I think it makes a difference. That form that was sent to you to be complete, it was actually sent to Susan to be completed, and her lawyer didn't know which of the two boxes would line up with that $144 or whatever the amount was, $1,000. And they said, hey, can you check the right box? Wouldn't let me finish. So that was sent to your guy. Not only did he never return it, But the document that I see in the record only has one box checked.
The pension plan box. Correct?
Matters the most. But anyway, am I correct that not both boxes were checked? Even had it been returned, he only checked one box.
Pension plan box. But I think it's important to look at the full context of what happened here. The form that's sent is blank. It has no boxes checked, nothing filled out on the form. There are 2 items listed, a GE pension plan and a GE security and savings plan. Susan's testimony that she was confused because she thought that Greg had a 401k. She did not believe that either one of those was a 401k. I think it's also important to keep in mind that Susan worked in the financial services industry.
Debunked, though, by the district court, I believe. They thought that he was making more hay out of that than it really was. If you want to look at the whole picture, I want to look at what he did, too. We're in a court of equity. Was he just really a lot better at hiding than she was seeking?
Depends, I think, on the credibility findings of the district court here, because Greg's testimony was different than Susan's on several key points, such as whether or not he had sent this form back to the legal assistant after he had completed it, and whether or not Susan knew about this pension plan that had been discussed during the course of the marriage.
Knew about it and she did not. And we're in a court of equity. Would you agree with me that he's better at hiding than she is seeking?
Probably be true in this context, then yes.
So her attempt to, well, I guess her fault probably was to believe him and to believe that he had revealed everything. That's where she fails here, is that she didn't dig deep enough?
It's an inadequate investigation on her part. Part of it has to go back again to those questions of credibility of Greg. He testified the reason he didn't disclose it was because he didn't believe it had any value.
It had vested 3 years earlier.
He believed that he had to retire as an employee of GE to get any money out of it, and he did not know if that would happen or not happen. So I think for the purposes of the appeal, the court should assume that he intentionally did not disclose.
Would return to your earlier line of thought. I think your explanation of the distinction between intrinsic fraud and extrinsic is right. But you were starting to distinguish that or analogize this to intrinsic because the fraud was in the stipulation. And my question for you is, does it matter that in this case, unlike a lot of other cases regarding stipulations, he had a legal duty to disclose under the discovery rules? And I haven't looked. I don't know if there was a pretrial order entered at this point in time.
Trial order requiring
Or disclosure provision in it.
were to disclose all assets, and it included a listing of retirement assets.
About analogizing the stipulation to the testimony and the perjury at trial. But does it matter that he had at least 2 independent sources of obligation to disclose, one by rule and one by court order?
I don't know that there's 2 independent issues there. I think when you get through the analysis here, we're in the after the 1-year equitable proceeding, and the last step of that is proving the elements of a fraud claim, where certainly a duty to disclose is part of that. Before you get to that, though, you have to determine, is the fraud intrinsic or extrinsic?
Then a personal injury suit where there would not necessarily be a rule that requires very specifically, in this case, disclosure of assets. I mean, that's not debatable. He didn't comply.
Personal injury example that was given, in pretty much any personal injury case I've been involved in, there are discovery requests, and one of those discovery requests is, do you have any pre-existing conditions? And then that was not disclosed. Now, certainly there, if there's a motion to compel discovery and an order to compel, then that strengthens the duty to disclose, I would guess. But still, I think there's...
Before the order requiring disclosure. I mean, it's a violation of discovery rules, but this just seems a little bit different to me because you have a rule that requires disclosure, and it seems different in this sense too, which is, as a branch, we've encouraged mediation and settlement of dissolution matters. That system really only works effectively where people are honest in their disclosures. Otherwise, if the contrary rule in this case is feel free to commit fraud, then you're just going to force the lawyers and the parties to demand discovery and get into the documents to confirm everything the other side has said, right?
I think what the court has to look at in the overall picture here is balancing the preventing and remedying fraud with ensuring finality of judgments. And if you kind of look at the progress of a case as a whole, you start out while the case is pending, there's discovery. The parties have a variety of mechanisms that they can use in discovery.
For the role of advisor to somebody during a mediation, and it's a high dollar dissolution case, tens of millions of dollars on the line. Are you going to feel comfortable not doing any discovery and trusting the financial affidavits if our rule is it's okay as long as you can hide it for a year?
I think, you know, any attorney has to balance those kinds of issues. How much discovery do I do? How comfortable do I feel with the information that I have? I think part of it here, and this may go more towards the reasonable diligence, is that GE consent form. To me, that GE consent form kind of raises a red flag. You know, what is this? Susan did not know what it really was. Her attorney did not know what it was.
Doesn't that sort of go to she should have kept asking? She got one answer that told her one thing, and she should have just kept going after it.
Asked about the GE consent form.
I mean, his disclosure didn't report this at all. Did she need to keep asking?
She didn't, as I had said earlier, she believed he had a 401k, and this form did not reference a 401k. So it appears to relate to something different, which then, to me, would trigger an obligation to investigate. And particularly when Susan testified that she was confused as to what it was, her attorney testified that she didn't really know what it was either. It could relate to a pension plan, it could relate to whatever the GE Security and Savings Plan is, and that really wasn't.
You just said she has an obligation to investigate. Is her obligation to investigate more meaningful than your client's obligation to be honest?
I think they're both meaningful. But here, what we're talking about, certainly he has an obligation to be honest. But we get into the reasonable diligence. Basically, if we have that obligation to be honest take precedence over everything, then there's no need for the reasonable diligence requirement in the law to investigate to discover a fraud.
Well, discovery was not easy with your guy. He got dinged $7,000 for, I believe, a violation of a discovery situation. It might have happened in the later lawsuit, but my point is, it's like pulling teeth, apparently, to get anything from your guy. So at what point does it's okay for her to say, Uncle, I have to go with what I've got. I can't prove anything else.
She's got to, once she's got that GE consent form, she has to follow up on what is this GE consent form.
Although he never followed up on telling her there's more to it, or providing her a copy to show he only checked one box. He had that burden, or he didn't have that burden, but she had the burden to keep pushing?
His testimony was that he had provided a copy to the legal assistant. The district court did not agree with that.
Have easily subpoenaed, sent a subpoena Dookies take them to GE and gotten the information that way?
That would be one option. Another thing, I think, to keep in mind is with GE, I think it would probably be fairly common knowledge that that is an old, established, large company, and those type of companies tend to have pensions. Now, a lot of those companies have gotten away from pensions, so he may or may not have had a pension just based on that alone, but I think it would kind of trigger an obligation to do a little further investigation, particularly when you have a form in front of you that says GE pension on it.
Let me come at you this way. In these kind of matters, you try and, kind of narrow the scope of disputes, as you know. It's about financial matters, and we try mediation, and you as a lawyer try and settle, you try and develop a framework, and ultimately you come up with kind of a stipulation if you're reasonably successful. And that limits the scope of the controversy. So in this case, she believes that there's a GE1 product out there. And then this form comes in. And she doesn't do a subpoena ducis tecum to see if there's two, because she's assuming husband has been forthcoming in the stipulations. I mean, I'm not sure, and please respond, I'm not sure the average lawyer seeing this kind of documentation in light of the stipulation would say, oh boy, we better go after GE. I think you would assume the good faith of the parties.
At least warrants a phone call to Greg to ask, what is this form? Because she believes he has a 401K, and this form does not reference a 401K. So it means something else. What does that mean?
Did he ever try to set her straight? Well, obviously you're talking about confusion. She thought there was a 401K. Did he ever set her straight? He never filed an affidavit of financial status. It sounds like just a game of whack-a-mole for her. And unless she gets the right answer.
Not ask. She believed that there was a 401K, and the 401K was disclosed in the stipulation. And then this form comes in that says GE Pension Plan, GE Security and Savings Plan, doesn't say 401K on it. To me, at that point, there is a question. And really, if you think about it, what is the reasonable diligence test? Basically, it's you have to follow all clues which would fairly advise a diligent person that something bearing on their litigation might be discovered or developed. This GE consent form is a clue that should be followed up on. And then this court's case law that's discussed in the briefing further says that you're basically, once you have that potential of something to follow up on, you're then charged with knowledge that you would have acquired by following up on it.
That both parties shall disclose their financial status. That's another big clue, isn't it?
But there's now a clue that perhaps something has not been disclosed that needs to be followed up upon.
Parties be able to rely on the veracity of financial affidavits and stipulations, especially in low-dollar divorce cases, or else we're going to prompt all this extra money spent on discovery.
There is, but then the question is, okay, once something is not disclosed, do you then have continuing litigation over those issues? And I think, the court has to consider, some of the potential fact disputes here. So is it a complete concealment? Is that a different rule than disclosing it but misrepresenting the value? What if Susan remembered that at some point in time you said, I think I have a pension plan with GE, so she's got some knowledge that it might exist, but she doesn't follow up on that. How does the court handle that? What if he says, I do have a pension plan, but it's worthless because I have to retire to get it, and then she doesn't follow up to see if that's true or not true? Okay. I think that's basically where I would end here. Thank you for your time, Your Honors.
Mitvalsky.
Thank you. There was not confusion about what the GE consent form was. That's been overstated. The only question was which one of the two accounts named on the form was the account that represented the $126,000 account. And so it's not a situation where Susan Hutchinson and her attorney received this form and wondered, oh my goodness, what in the world do we have here? Mr. Hutchinson testified himself, and this came out in the trial record, he said what it related to, just changing the death benefits on his retirement, the retirement account that he had disclosed. So there wasn't confusion and bewilderment about what this form was. It was just misrepresented. And I want to make sure the court appreciates the sheer intentionality of this concealment. And we can see it by the violation of mandatory disclosure orders. We can see it in terms of signing stipulations saying he'd fully disclosed when he hadn't. But we can also see from what he did in this particular case that Mr. Hutchinson wasn't about to let Susan Hutchinson know about his pension until he was ready to do that. In this case, from 2016 until 2019, he had no less than 5 discovery violation orders entered against him, orders to compel, orders for sanctions, all relating to investigating the same defined benefit pension that he intentionally concealed previously. And if you listen to his testimony, this was a rare case where in 2019, we were able to apprehend through his testimony what his 2010 state of mind was. He said it at trial and in a deposition, but at trial. He said his attitude was, Susan didn't deserve any part of this pension. He said that, and he said he knew the mandatory disclosure order required him to produce this information, and there was nothing preventing him from doing so. He could have done it, and he didn't do so. And then he says, and if they can't find it, it's on them. That's egregious, and it might go to some of the questions about where a limiting principle might be here.
Back to my personal injury example, you have exactly the same thing. We have our disclosure rules in place, require the plaintiff to disclose in a personal injury case all their health care providers over the last 5 years. Somebody doesn't do that.
Intentionally concealed, then that would be a ground to vacate the judgment. If there's intentional concealment, if that can be proven, extrinsic fraud after a year, it's grounds to vacate the judgment. And I'd like to be clear here on the kind of fraud that we're talking about, because we don't agree that the kind of fraud that we're relying upon to come in after 1 year is false swearing on the stipulation of settlement that he signed, swearing that he made full disclosure. That's certainly one kind of fraud that happened here, and that could even be intrinsic fraud. But the act of concealing the subject matter itself, the act of intentionally concealing the pension, is independently a fraudulent act. And because that pension, the subject of that pension, was never permitted to become intrinsic to the original proceeding, it remained extrinsic by reason of the intentional acts to conceal it. We're dealing with extrinsic fraud.
Confusing me is what's the subject matter, because in a dissolution, the subject matter is all about the assets, and his pension is one of the assets. So if we go your route, I worry that there's no more finality anytime somebody down the road discovers their ex-partner lied about something, or their opposing party litigation was untruthful in discovery, and then years later we can reopen.
Is the defined benefit pension here, and what I'm focusing on is, when I use the term subject matter, I'm focusing on the asset itself. And yes, what I'm advocating here is that if we're dealing with a material asset, which has to be proven first before you even get to this point, but if we're dealing with a material asset, and the proof is it was intentionally concealed in a way that affected the outcome such that there couldn't be an adjudication on that matter, which is here. Whether we're at a trial or whether at a stipulation, Your Honor, the stipulation gets submitted to be decreed, it's an adjudication, and here the stipulation was completely silent on anything having to do with the defined benefit pension because it was concealed and kept extrinsic.
Statute that allows up to 10 years after a marital dissolution, if there's it's discovered that an asset was intentionally concealed, that it can be forfeited to the other side. Maybe Iowa should have that statute, but we don't.
The court can effectively do the same thing here, and until the legislature acts, and maybe it should, the message can be the same, and that is to say, you know, to answer the question about subpoenaing here, and I see that my time has expired, if I may just have a moment to wrap up. The message can be the same, and it's what I said earlier. If you engage in this type of intentional concealment, you should not expect to be able to avail yourself of a defense on reasonable diligence, and you should expect that the decree that was entered dissolving your marriage might be subject to modification. If I may speak to the subpoena question, I see my time is over.
Seconds.
To subpoena something from GE, you'd have to have a suspicion that there's something there. And here, there was no suspicion. There would be no limiting principle to that question. If you have no suspicion of a pension, you have no suspicion of concealment, of refusal to cooperate, et cetera, do you send a subpoena to the current employer? Do you send it to the last 3 employers? Do you send it to every single employer the person has ever had? That's not the right place to draw the line. That's not a fair characterization of reasonable diligence. That really would be the shapeless principle. Thank you very much, Your Honors, for your time.
Just in case, the case of State versus West Vangan is also hereby submitted, and court is adjourned for the day. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.